If it wasn't made clear from our class on relevance, identifying the purpose for which we're seeking to adduce the evidence is of utmost importance. And indeed, this takes on a particular salience when we're talking about credibility evidence. First, we need to understand the definition. So let's take a look at section 101A. Credibility evidence in relation to a witness or other person is evidence relevant to the credibility of the witness or a person that A, is relevant only because it affects the assessment of the credibility of the witness or a person, or subsection B, is relevant because it affects the assessment of the credibility of the witness or person, and for some other purpose for which it is not admissible or cannot be used because of a provision of parts 3.2 to 3.6. Now, while subsection A seems fairly straightforward enough, it's subsection B that often requires a bit of an illustration to truly understand how it works. So let's take a look at such an illustration. Meet Andrew. Andrew is charged with assault occasioning actual bodily harm stemming from a fight that allegedly occurred at his workplace. If we take a look at the provision, we can see what the Crown has to prove. 1, that an assault occurred, and 2, that this assault occasioned actual bodily harm. Now, without knowing more, assume the following. Andrew, having worked at this place for quite some time now, has over the years received 3 reprimands from his workplace from alleged stealing of office goods, including a stapler, an office computer, and a computer chair. Whilst none of these incidences had been proven, the discussions around the workplace, the hearsay, and the conjecture were deemed serious enough for human resources to have given him these warnings. Assume that evidence of these 3 incidences reached the desk of the Crown Prosecutor. Could the prosecutor adduce evidence of these reprimands in a subsequent trial of Andrew for his assault charge? Or, in other words, are they relevant? Well, without more, no. It's evidence that speaks to, well, dishonesty, or, in other words, only to the credibility of Andrew. Thus, as per the definition in section 101A, subsection A, evidence of these previous workplace reprimands would be relevant only because they affect the assessment of the credibility of Andrew. And thus, under section 102, would be prima facie inadmissible. But let's change the facts a little bit. Instead of being charged with assault occasioning actual bodily harm, let's assume that Andrew instead is accused of having stolen funds from the company's bank account over the last 3 years, and consequently has been charged with embezzlement under section 157 of the Crimes Act. Do these workplace reprimands now take on a different character? Well, yeah. Not only do they speak to dishonesty or the credibility of Andrew, but they also potentially reveal something else. That is, a potential tendency towards engaging in dishonest behaviours in the workplace, which could potentially be relevant to a charge of embezzlement. Thus, with reference to the definition in section 101A, these previous workplace reprimands no longer are relevant only to the credibility of the witness, and thus, prima facie, are not made inadmissible by section 102. If, however, the evidence is inadmissible for its tendency purpose, that is, it doesn't satisfy the test in section 97, which we'll cover in another class, section 101 capital A subsection B renders it credibility evidence, as it affects the assessment of the credibility of the witness and cannot be used for its other purpose because of a provision in part 3.2 to 3.6. And that is just in relation to the definition and identification of credibility evidence. Once we've identified the evidence as such, the next question is, how can we adduce it? So, let's take this sequentially. What are the questions you have to ask yourself? First of all, is the impugned evidence relevant to a fact in issue? Or is the evidence captured by the definition of credibility evidence in section 101A? That is, it is relevant only because it affects the assessment of the credibility of the witness or a person, or it affects the assessment of the credibility of the person, and it is inadmissible or cannot be used for its other purpose. Once you've identified it as credibility evidence, the next step is to identify the default position in section 102. That is, credibility evidence about a witness is not admissible. But wait, there are exceptions. And our first exception, upon which the others are predicated, is that found in section 103, cross-examination as due credibility. Now read the provision. What do we think are the key words there? That's right. First, it must occur in cross-examination of the witness. That's our procedural aspect. And secondly, it must satisfy the threshold of substantially affecting the assessment of the witness's credibility. But enough with just the recitation of a provision. Let's take a look at an example. Let's take Andrew again, being on trial for assault occasioning actual bodily harm. It's the Crown case that Andrew was having an argument with his office workmate Tony when, out of nowhere and completely unprovoked, Andrew lashed out at Tony, punching him in his nose, causing a minor fracture. Andrew, however, recalls the incident to have been quite different. According to Andrew, it was Tony who started to get aggressive and lashed out at him unprovoked. Andrew, dodging this punch, swung back with a strike of his own, causing the subsequent injury upon Tony. In other words, Andrew is relying on the defense of self-defense. So, now we're in court. Assume the Crown case is closed and Andrew elects to give evidence in his defense. Andrew's barrister conducts the examination-in-chief and elicits evidence of what occurred during the alleged incident. His examination-in-chief complete, the Crown prosecutor now approaches, beginning her cross-examination. The Crown prosecutor wants to cross-examine Andrew on his previous workplace reprimands. What must she do? First, is the evidence relevant to a fact in issue? Without more, no. But we've already established that the evidence is potentially credibility evidence, as it speaks to the dishonesty of Andrew, or potential thereof. Having identified it as credibility evidence, what's the default position? And next, where is our first relevant exception? In cross-examination of the witness. Now, we're already in cross-examination of Andrew. That's the procedural aspect satisfied. Next, the Crown prosecutor needs to satisfy the threshold test. That is, could these 3 previous workplace reprimands substantially affect the assessment of the credibility of the witness? However, even if Section 103 is satisfied, because it is the accused against whom we're seeking to adduce this credibility evidence, the Evidence Act affords them an additional protection. That is, the protection contained in Section 104. And, as you would have covered in class, Section 104 contains those additional procedural requirements that must have been satisfied in order to cross-examine an accused on their credibility. But what about Section 106? Where does that come into play? Well, let's take a look at another example. Say hi to Ruby. Ruby has been charged with the possession of a prohibited drug under Section 10 of the Drug Misuse and Trafficking Act. According to the police statement of facts, Ruby was driving erratically down the road, and 2 officers who noticed her driving pulled her over. As one of the officers approached Ruby in order to obtain her license, he stated that he noticed she appeared somewhat agitated and nervous. The other officer, approaching from the rear of the car, looked through the open rear window and noticed on the back seat a little baggie containing a white powder of some sort. The officers asked Ruby what it was, and she replied she didn't know and had no idea how it got there. Unfortunately for Ruby, subsequent forensic analysis revealed the substance to be 0.9 grams of methamphetamine. For Ruby, however, this police account is just complete nonsense. She does not deny that she was driving on the road, nor does she deny that the police pulled her over. However, she claims that she was indeed driving under the speed limit, and when the police officer approached her to ask for her license, she pressed that point. As she continued to argue with this police officer, she looked in her rearview mirror and noticed the second officer reaching into the back seat and seemingly dropping something, with the obvious suggestion being that the drugs that were quote-unquote found by the officers were in fact planted there by them. Fast forward a little bit. Assume that in preparing the defense for Ruby, Ruby's barrister comes across some information concerning the investigating officers. More specifically, the defense barrister has come across a person who used to work with one of the investigating officers and even gave evidence to the Wardwell Commission in the 1990s, stating that this officer had previously taken bribes from criminals. So we have a defense witness and we have the evidence that they could potentially give. Is it relevant to a fact-in issue? Well, no. Without more, we don't think so. However, it's clearly relevant to the credibility of the key investigating officer. So clearly, the defense would want to get this evidence in. Now, as we looked at in the previous example, the key exception that first needs to be satisfied is that contained in section 103, that is, in the cross-examination of the witness. So, the investigating officer during the Crown case has given his examination in chief. Now, Ruby's barrister conducts his cross-examination. Assume that it's already been established that the evidence meets the threshold requirement, that is, if accepted, it could substantially affect the assessment of the credibility of the witness. Ruby's barrister puts it to the police officer. Isn't it true that you had previously been alleged to have taken bribes from criminals? Realistically speaking, what options are available to the police officer? He can either say, yes, that's true, and risk impugning his credibility directly, or he can deny the proposition being put to him. No, that's garbage, that never happened. It is if this latter course is adopted by the police officer that we can use another section to nevertheless adduce this credibility evidence. And this is where our exception contained in section 106 comes into play. Subsection 1. The rule does not apply to evidence that is relevant to the witness's credibility that is adduced otherwise than from the witness, if the substance of the evidence was put to the witness and the witness denied or did not admit or agree to the substance of the evidence. We have here Ruby's barrister, who put the substance of the proposition to the witness, that is, he had previously been under investigation for corruption, and the officer said, no, that's not true. Thus, if the court gives leave, or under subsection 2 leave is not required, Ruby's barrister can seek to adduce this evidence in the examination in chief of Tony. That, in a nutshell, are the very, very bare bones of how to adduce credibility evidence.